Morning in New York. Good morning in New York and the Americas. Good afternoon in Europe and Africa. Good evening in Asia, and good night. And welcome whatever time of day or night for all of you who are joining from all corners of the world. I'm Yael Danieli, founder and executive director of the International Center for the Study, Prevention, and Treatment of Multigenerational Legacies of Trauma, ICMGLT for short. Thank you very much for joining our webinar today. This International Center for Multigenerational Legacies of Trauma webinar is held not only in observance of 17 July, the International Day of Justice, but this year also of the 25th anniversary of the Rome Statute of the International Criminal Court, or ICC. The Rome Statute of the ICC, adopted on 17 July 1998, contains significant norms and standards on victims' rights. It expands the regime of protection for victims and witnesses that already existed in the ad hoc international jurisdictions. It introduces for the first time victims as participants in international criminal proceedings, and it creates a system of reparations that was designed to complement the pre-existing responsibility of states in ensuring effective and available remedies for victims of international crimes. Looking back at the last 25 years, with a view of thinking forward to the next 2 decades and a half, this panel will try to assess the impact of the Rome Statute on the practice of states and other subjects of international law in respect of victims and affected communities. Experts, practitioners, and activists on victims' rights will analyze what was or should have been accomplished by the ICC and its 123 state parties in the promotion and realization of victims' rights, and lay out their vision for the next 25 years. This webinar would not have happened if it weren't for the generosity and dedication of ICMGLT's Advisory Council member and co-chair of ICMGLT's Working Group on Justice, David Donat-Katin, who will co-moderate today's webinar with me. Dr. Donat-Katin is adjunct professor of international law at NYU Center for Global Affairs and Advisory Council member of ICMGLT. In 2014 to 22, he was Secretary General of Parliamentarians for Global Action. Since 1995, he had been a civil society actor in the processes of negotiation, ratification, and implementation of the Rome Statute of the ICC. He was a co-founder of the Victims' Rights Working Group of the Coalition for the ICC. Your moderator, I, am a clinical psychologist, victimologist, traumatologist, and psychohistorian. I devoted much of my career to studying, treating, and preventing multi-generational impacts of massive trauma, to victims' rights, to rights of future generations, and to reparative justice that views the justice process, not only the outcome, but the moment to moment and the totality of the relationship of the justice system with the victims, as offering opportunities for and is experienced by the victims as healing and repair. My version of psychohistory is related as it is dedicated to articulating history as it is lived, rather than it is written about. As the only living participant in creating all key international law instruments on behalf of victims' rights and optimal care, I too co-founded the Victims' Rights Working Group of the CICC and hold the ICC's provisions for victim survivors as the beacon for the world's community as a whole, internationally, nationally, and locally. The International Center for MultiGenerational Legacies of Trauma is particularly honored today by the co-sponsorship of Costa Rica and Germany. It is my honor to welcome the greetings of Her Excellency, Ambassador Maritza Chan Valverde, Permanent Representative to Costa Rica to the United Nations in New York, whom I had the pleasure to meet yesterday. Ambassador, the screen is yours.
Thank you very much, colleagues and friends. It is an honor for Costa Rica to be part of this first commemorative event on the 25th anniversary of the Rome Statute ahead of the July 17th, which is also World Day for International Justice. ICC represents our collective commitment to combat impunity and hold accountable those who perpetrate the gravest crimes. The question is no longer whether accountability is necessary, but how it's best achieved. So please allow me to make some points. First, we must guarantee that progress and accountability is not constrained by states that have not yet joined the Rome Statute. When we fixate on the absence of some member states, we buy into the myth of the exceptionalism and stunt the progress of international justice. Second, Costa Rica believes that it's crucial to dismantle the notion that international justice through the ICC is an admirable but unobtainable goal. The responsibility of justice lies with the states. The responsibility to ensure that alleged perpetrators, when charged, are turned over to the court for trial. The responsibility to ensure that once convicted, perpetrators can be encapsulated in facilities that meet international standards. The states might also ensure that witnesses are protected from reprisals and that victims can be offered reparations that go beyond cash disbursements. It is incumbent upon us to ensure that adequate resources are available to conduct fair trials that lead to unsellable judgments and which protect the safety of victims who choose to cooperate with the court. Third, Costa Rica wishes to recognize the service of prosecutor Fatou Bensouda, who played a key role in the implementation of the provisions of the Rome Statute, particularly in the investigation and persecution of sexual and gender-based crimes. To honor her work, I would like to encourage the progressive promotion of the Rome Statute's legal framework by adopting an intersectional approach in all persecutions, particularly those involving sexual and gender-based violence committed as a tactic of war and armed conflict. Bensouda's important activities in this area also reflect the legacy of Costa Rican Judge Elizabeth Odio, who in 1998, during her term at the International Criminal Tribunal for the former Yugoslavia, successfully worked to have rape and other sexual assault considered forms of torture. Odio Benito's interpretation is now an accepted principle of international law. Let us renew our commitment to the ICC. Let us defend its impartiality, its complementarity, and its promise for universality. Let us act first and foremost in defense of human dignity and the right of peoples not to suffer great crimes at the hands of state and non-state actors without the promise of justice. I thank you.
Thank you so much, Ambassador Valverde. His Excellency, sorry, actually we have 2 women ambassadors, which is marvelous. Her Excellency Ambassador Anja Linders, permanent representative of Germany to the United Nations in New York, is attending the Security Council open debate on conflict-related sexual violence. She therefore kindly honors us via a pre-recorded video. Rabbi, would you please share the video with us?
Colleagues, dear Yael, Germany is proud to co-sponsor this side event together with Costa Rica. And I should thank you for giving me the opportunity to say words of welcome at the beginning of this timely webinar, highlighting the perspective of victims as we approach the 25th anniversary of the Rome Statute. In a few days, we will be celebrating the International Criminal Court as the most significant achievement in the international community's efforts to end impunity for the most serious human rights abuses. This is particularly true for the victim-oriented provisions of the Rome Statute, which have lasting impact on the practice of states. These provisions have been a major step forward in protecting victims' interests and in giving victims a voice. The Rome Statute stipulates that victims' interests will be taken into account at all stages of the legal proceedings, ensuring in particular that the emotional and physical well-being of victims is protected. Importantly, the opportunity for victims to seek reparation injected an element of restorative justice into international criminal law. How best to implement these provisions and how best to give full meaning to the rights of victims has been a major concern for the International Criminal Court since its inception. I'm glad to see Judge Bertram Schmidt on the panel with his vast practical experience on how to make victim participation work in the courtroom in The Hague. And I'm convinced that Germany's candidate for the ICC judicial elections taking place at the end of this year will make an equally lasting contribution to the court's judicial practice. I wish you a challenging exchange. And I look forward to continuing our work towards full accountability for the most serious crimes. Colleagues,
thank you very much, Madam Ambassador, and thank you very much, Yael, for the very, very generous words of introduction. Now we can really start with our panel. And as the Ambassador of Germany clearly stated, the Rome Statute provides with a framework for victims to be participating in proceeding for their well-being, not only their privacy, security, and safety to be protected, as well as to access and obtain reparations. So we have invited a distinguished list of experts, and the first one that we have invited has been invited already 1 year ago when we celebrated, or maybe we marked with some criticism, depending on the perspective, the 20th year of the entry into force on the 1st of July 20.
Не можу зараз, вибачте, потім прозвоню. Все, дякую, дякую.
We have one voice that needs to be muted. Thank you very much. And 1 year ago, it was Carla Firstman, who is going to be our first speaker, who presented on behalf of herself, but I believe on behalf of many others in the room, the state of the art of the court practice on victims' rights. So today we invited Carla to have a broader perspective, the impact of the Rome Statute on the last 25 years with the view of looking at the next 25 years. And we are inviting all the speakers to make a reflection on this major point. Carla is a professor of law at University of Essex Law School in the United Kingdom. She's a Canadian national. She was for many, many years the director of the NGO with a leading role on victims' rights redress in London, and a recognized expert in international human rights law and international criminal law. Carla, it's an honor to have you with us.
Thank you so much. I think the honor is really for me. It's a great honor to be here. It's a great pleasure to be here. And the timing of this event couldn't be better. It's nice to be with some old friends and some new friends. So in looking at victims' rights 25 years in, 25 years onto the future, I think to start, it's important to recognize that the very existence of the ICC and the promise of accountability that it brings is already a symbol of hope for victims, not only for what happens at the ICC itself, but the era of the ICC is an era which has mobilized civil society around the world to call for accountability, to press their own governments to enact legislation, to investigate and prosecute mass crimes, and to provide reparation to victims. I don't think we should underestimate the importance of this. The civil society movement for justice, it's global, it extends to the grassroots in all parts of the world, and it is insistent. So something that I would like to see, and I think is really important, is for this global movement for justice to become even more interconnected across countries and continents, for it to become more survivor-centered, and for the global movement to serve as both a vehicle for survivor empowerment, but also a safe space to address issues like trauma, like fear, and challenges associated with the day-to-day. We can already see some of this happening with the movement to address sexual violence and conflict. But I think there's a need to think even bigger, even broader than this. On what I would like to see at the ICC itself, I'd like to see the really important groundbreaking provisions on victims' rights, victim participation, reparation. I'd like to see these groundbreaking provisions translated into procedures that are practical and effective. Too often, we ourselves, but our colleagues at the court, we can understand, are saying, well, you know, but it's difficult. There's so many victims. I think 25 years in, it's time to rise to the challenge. But what does this challenge actually require us to do? Of course, we need to rise to the challenge. On victim participation, what I think needs to happen is for the ICC to rethink what it sees as the purpose of victim participation. To my mind, it shouldn't just be about lawyers ensuring that victims' legal interests are taken into account in the proceedings. It should be about victim empowerment. It should be about victims' voices and that ubiquitous two-way communication where each side is happy to listen and to be transformed by the other. Right now, there's too much of a one-sided dialogue with the victims. The victims are hearing about and needing to understand the constraints set by the court. So one needs to rebalance that communication so it's really a two-way communication. Also, I think with our experience of COVID, we have a lot of experience of online technology. We should be using modern technology to enable more victims to participate practically in proceedings wherever they are. Of course, the system of common legal representatives is crucial to ensure that victims' legal interests are protected in proceedings, but victim participation is not just about protecting those legal interests. It's about victim empowerment, actually hearing from victims, listening to them, and having their voices matter. So there really isn't a reason why judges cannot hold hearings in local communities using video technology, for example, or of why victims can't participate in Hague-based hearings through remote networking. Certainly, this isn't to say that in-person meetings are not vital, but using video technology can assist. Also, we should let victims engage more seamlessly at the preliminary examination and pre-confirmation of charges phases, where their interests are clearly affected. Victims have distinct interests in prosecutorial strategy, and particularly in decisions taken to proceed with an examination and later an investigation, on decisions not to proceed or to hold an investigation in limbo. Giving greater space to victims during those early phases does not reduce prosecutorial discretion. It simply increases the accountability for the exercise of prosecutorial discretion. Practically, this means ensuring a modicum of legal representation during those early phases and creating more space for judges to hear from victims formally. On reparations, I think there's still much room for improvement. The major challenges that I see, the ICC system is such that orders for reparations are made against convicted perpetrators, whereas the harm that victims suffer is caused not just by individual perpetrators, but by governments, by corporations, by opposition groups, etc. Perpetrators typically have no funds, so the system of reparations is mainly funded by a charitable framework. Under a system of charity, the link between the wrong and the harm and victims' rights to reparation is broken. Everything becomes about needs, vulnerability, and the nice trust fund doing what it can without the accountability of victims' rights. This defeats the affirmative empowerment part of what reparations should be about. It does not do much to restore victims' sense of strength, their sense of empowerment or dignity. Also, when the ICC gets involved, it gives some countries where the crimes occurred, who should really be implementing large-scale reparations programs themselves for the mass victimization that has happened in their countries and for which they typically bear some responsibility. But it gives these countries a chance to escape scrutiny. Attention is deflected to the ICC's charitable assistance wrapped up as reparations, and the state, meanwhile, does little for victims. So these are massive problems, not easily fixed, and have a lot to do with the limitations of mandates. I would like to see the ICC innovate more in this regard. For example, by using the state cooperation frameworks in the statute to break through these barriers. Work should be done to ensure that the ICC court judgments can serve as a catalyst for action, not just action at the ICC, but domestically, regionally, to ensure that real reparations actually happens. This can be helped by setting up national reparations working groups, which involve the ICC, states parties, NGOs, victims groups to break through these barriers. We're too often working in silos, and that has the tendency to disadvantage victims. A lot of asks I'm coming with, but also a lot of motivation. And I hope through this webinar and through the work that needs to continue to happen, we progressively find some solutions. Thank you.
Thank you, Carla. We can start working hard again. Let me go on. It is my deep honor to introduce Judge Bertram Schmidt, judge at the International Criminal Court, presided over several trials since 2015. With 23 years of experience in the German judiciary, he previously served on the bench of the Federal Court of Justice, the Supreme Court of Germany. For many years, He was an ad hoc judge at the European Court of Human Rights and a German member of the Joint Supervisory Board of Eurojust. Judge Schmidt, it's so good to see you.
Well, thank you very much. It's so good to see you, Yael and David. It's a pleasure and an honor for me to speak at this event, specifically about participation of victims and about the well-being of victims. And what you can expect from me is that I will speak about my practical, and underline practical, experience with several trials at the ICC.
Right.
I want to start with the contribution of participating victims. We all agree that the participation of victims in the proceedings is a major achievement of the Rome Statute. Those who have suffered, those who have experienced firsthand the worst human rights violations imaginable, are not only the mere objects of scrutiny by the parties and the judges, but they are active participants in the proceedings. And their contribution is manifold and important. Let me just give a couple of examples. In the Ongwen case, the defense had argued that Dominic Ongwen should undergo mechanisms of Acholi traditional justice instead of criminal procedures before the ICC. We, as the judges, took this claim very seriously. After all, it touched the legitimacy of its formal criminal proceedings. In its judgment, the Chamber has rejected the claim by the defense. In reaching its decision, it has relied to a great extent on the views and concerns of the victims. Mr. Manova will also speak later. He will recall that vividly. Because the victims had expressed in the strongest terms that they opposed the idea of traditional justice. Furthermore, the victims' representatives in the Ongwen case presented evidence which enabled the judges to understand much better what lasting impact traumatization has on the life of survivors. In the Al-Mahdi case, which dealt with the destruction of World Heritage sites in Timbuktu, the contribution of the victims was invaluable to our understanding of the social and cultural background, specifically what the destruction of the mausoleums meant for the collective identity of the people of Timbuktu. Generally speaking, the testimony of victims is indispensable for the chamber, for any chamber, to determine the facts of the case. It is as well important for sentencing factors like the gravity of the crime and its consequences for the victims. And this already leads me to the physical and psychological well-being, dignity, and privacy of the victims. Before I speak more in detail about that, we have to ask ourselves, why is it so important? The starting point is to realize what it means for these witnesses to testify before the ICC, what they have to take upon themselves to do so. We have to keep in mind that these are human beings who have experienced the most horrific crimes, perpetrating against themselves, the family members, or members of their community. They are thus, for the most part, deeply traumatized. And I do not want to stay in the abstract here. When we speak about witnesses, we should give examples. We should let them speak. And I hope to illustrate with this example what I mean. I'm speaking of a woman, a lady who was a witness in the Ongwen proceedings. During an attack on her village, this witness had experienced and seen how her neighbors were indiscriminately massacred by the LRA with firearms, machetes, and clubs. She saw how 3 4-year-old children were chased into a hut and burned alive in it. One of these children was her own child. She herself was abducted with many other villagers and forced under constant beatings to transport plundered goods on her back and her head. Since her baby, who she was carrying on her back, prevented her from carrying more, the perpetrators tore it away from her and threw it into the bushes. Her child was later found, but was left with permanent brain damage. Now the court depends on such witnesses to be able to provide documented proof of the crimes. At the same time, however, everything possible must be done to avoid secondary victimization, to avoid that the witness suffer even further and potentially even more profound psychological harm by testifying before the ICC. Not to take this into account would mean that the court would potentially establish the facts of the case at the expense of those who have suffered the most. So how does the ICC try to preserve the well-being of the victims? All trial chambers have established extensive so-called familiarization protocols, which regulate the necessary measures in detail. Today, I can only give you an idea what this practically means. In the particular case mentioned, the witness was already assisted by a staff member who traveled with her from Uganda. She left for her testimony in The Hague for the first time her village in Uganda. Like other witnesses, she was housed in The Hague in secret and secure accommodations. During her stay, she received further psychological and social support. During the hearings, she was also accompanied by a member of the psychological support staff of the court. In addition, efforts are undertaken to dispel the witness's understandable fear of testifying and familiarize them with the situation that awaits them. This is necessary because the situation of being questioned at the ICC can be downright terrifying. The things that are done to help in this regard are, if you like, banal, but their benefit should not be underestimated, specifically the psychological benefit for the victims. For example, the witnesses are shown the courtroom. Anyone who has been to The Hague and looked around the court knows why. Specifically, courtroom 1 is huge and intimidating. Witnesses are told in the courtroom which participants in the trial will sit where and what their function is, so that they understand the next day what is going on. The witnesses have also to be treated with the utmost respect during their questioning. Before starting, the presiding judge welcomes them on behalf of the chamber to the courtroom. I underscore the importance of their evidence for the determination of the truth, and I thank them for having made themselves available as witnesses in the proceedings. Nonetheless, the witnesses have to subject themselves to questioning that casts doubt on their experience as victims. There is no way of avoiding this if the defendant is to be ensured a fair trial. It is the job of the presiding judge to protect the witnesses from overly aggressive questioning, thus to protect him or her from being intimidated or even further traumatized by the parties' examination. However, I was, and I'm still surprised how amazingly well witnesses deal with the situation of being examined, even with questions that put their evidence into doubt or accuse them of outright lying. Many witnesses display a great resilience during their testimony. One gets the impression that speaking before the chamber and the confrontation with the perpetrator in the courtroom can also mean an empowerment for the victims. I would again like to give you an example. The questions went something like this. I quote, "I put it to you, you weren't at the crime scene and thus you have also never seen the accused. Everything that you are telling us is made up." The witness's response was, "You have your truth and I have mine, but mine will stay." Nonetheless, why do the witnesses take on the physical and above all psychological strain of testifying before the International Criminal Court? For of course, no matter how we prepare them, no matter how attentive we are, no matter how much support staff is around them, testifying will bring back the memory of their traumatic experiences. The witnesses have to tell people unknown to them about what they went through. These are, I remind you of the example, horrifying atrocities. These are acts that profoundly touch the witness's private life. I would only like to mention additionally here victims of sexual crimes. Needless to say, the witness's motivation for testifying before the ICC is not always the same, but there are patterns. Many of them express that they see their testimony as a chance to tell their story, and they want to contribute to the determination of the truth. Typical is the testimony of a witness who was kidnapped by the Lord Resistance Army as a little girl. She was forced into marriage with a commander when she was 13 years old. She was raped for the first time immediately thereafter, and then held in sexual slavery for many years. On her psychological state, she had the following to say, I quote, "My heart was broken. I still feel the pain every day. I have never known peace in this world." Nonetheless, she came to The Hague to tell what happened to her. She explained why in these words: "I want to help the world to find out what happened. I pray for this court to provide some justice." Finally, the aforementioned witness, one of whose children was burned alive before her eyes, and whose other child is severely disabled, provided especially vivid and touching testimony. She simply said, I quote, "I have come here for all of you." I think there is no better way of summing up the basic idea of international criminal justice. Namely, that although crimes under international law may, from our perspective, from countries living in peace and economically well off, that they may happen far away geographically, but they nevertheless concern the entire international community. I come already to my final remarks. The victims have suffered immeasurably. They have a right not to be forgotten. To listen to their stories is, besides the forensic relevance, for me, also a profoundly moving experience in human terms. The victim's testimony over all these years has inspired my deeply felt respect for the courage of these people who, despite the suffering that they have experienced, despite their traumatization, despite the burdens associated with their testimony, are willing to testify before this court and help us to determine the truth. And they are doing this. Let me take up here what the already mentioned witnesses said. For all of us, and in the hope for some justice. I hope that we can live up to this. Thank you very much.
Thank you, Judge Smith. And this really is a confirmation of the fact that the Rome Statute system really is based on pillars like the articles and the rules of procedure and the great theories, but we need the human beings being able to interpret and apply. And Judge, when I was in the Hackathon trial on the same day when Mr. Putin got indicted on the 27th of March, you were continuously closing the session. Everybody was frustrated. I was the happiest man in the courtroom because I was saying, here is a judge who's protecting the vulnerable victim's witness, who is now questioned by the defense lawyer, who is trying to say something that shouldn't be said publicly because it may be very dangerous, and he wants to stop her. So I really thank you for your everyday work. You have been the presiding judge in each and every trial you attended. And I think it's a demonstration of how important the work of judges is. Now, this year, we are going to elect 7 new judges. So this is really a testament of the important quintessential role of your profession. Yael, before I introduce Alexandra,
might I add that indeed the applicants for judgeships should listen to you as part of their training. But both listening to Carla and to you, I was again and again feeling confirmed about the importance of reparative justice, and that this is how the training in law schools and in practice should go around the world. And I have a question which you may or may not want to address here, totally understandable. As the listener to these stories, what is the effect on you?
Well, that is, you know, I fancy, or I tell myself that I treat this professionally because I'm a judge since so many years. But still, when I'm, you know, I have heard these testimony that I referred to in my presentation. I have heard it live, and it moved me deeply. So I'm even, let me word it, and you might find this strange this way, but I still am moved by and touched by what I hear. Yeah. Although it is, of course, clear in the situation, I have to treat it specifically as presiding judge in a professional manner. That is perfectly clear. But on the other hand, we are not automatons.
Exactly. And part of reparative justice is to include the notions of protection to the listeners too.
Yeah, well,
the listeners get traumatized whether they like it or not.
Yeah. Well, just a word on that, of course, and because also David mentioned it, I think I understood that I speak beyond the safety issues, but this is, of course, extremely important. The protection, you know, of the identity of the witnesses, not only for their safety, but also when it comes, for example, to crimes of sexual violence, and of course, then you have to go in and out and more in closed session, like David said. This is not satisfying, of course, for the listeners, but it has to be done for the protection of the privacy of the witnesses.
Thank you, Judge. And let me just say here before we move forward. I was in the Tadic trial opening case, 1995, and in the Akayesu trial opening session in 1996 in Arusha. So the first 2 trials. And in the first one, as a law student, I was shocked there was no victims in the courtroom. But, you know, then I learned, well, victims have no standing in international criminal justice procedures. When I was in Arusha, as part of the Arusha School on International Criminal Law, International Humanitarian Law and Human Rights with my former organization, the European Law Students Association, I was in the public gallery, and there were 2 representatives of victims of 2 associations, Abuca and Ivega. And the registrar of the ICTR told them, go in the gallery where the students are, where the law students are, where I was sitting. And they didn't come. They just left Arusha as a storm, saying, we have no place here. And that's where the proposal of writing the current text of Article 68, paragraph 3 came to my mind and to the ones of the colleagues attending that project of the European Law Students Association, the African Young Lawyers Law Students Association, and Avocats Sans Frontières. And I think the entire movement supported this, especially the Women Initiative for Gender Justice with Professor Rhonda Copeland, who's not anymore with us today. Of course, Yael was a major ally. So all these things that happened more than 25 years ago, thanks to your work, are coming today to real life, to fruition.
Again, thank you very much for the invitation. And I told you that I have another commitment, which was already a commitment before the invitation came. So please allow me to leave now. And I hope to see you and Yael soon, wherever and whenever. Have a wonderful event now. Bye-bye.
Thank you, Judge.
Thank you so much, dear.
Our meeting continues with the voice that is most known probably among all of us. My dear friend and colleague Alexandra Mantwychuk, who is connected with us from Kiev. She's the executive director or the head of the Center for Civil Liberties, an NGO that received the Nobel Peace Prize in 2022, alongside many other recognitions that she proudly and deservedly received. As a human rights lawyer and recognized leader of the peaceful Euromaidan revolution of 2014, Alexandra investigated human rights abuses and atrocities committed in the occupied territories of Ukraine for almost a decade. Since February 2022, she launched a seminal project entitled A Tribunal for Putin. We are really thankful to have her today to honor us with her presence, and also for her presence to be fully appreciated in her own language. We have our interpreters, Gana Stembrovska and Natalia Zayets, who will be helping us to translate her and all the interventions of this webinar. Alexandra, I had the privilege of working with you in my previous job for so many years, and it's so nice to have you from Kiev. Please take the floor.
Thank you very much for providing me a floor. It's a huge honor for me to address to this distinguished audience. I'm a human rights lawyer, and I have been documenting war crimes since the 2014, because this Russian war started not in February 2022, but in February 2014, when Ukraine obtained a chance for the quick democratic transformation after the collapse of the authoritarian regime due to Revolution of Dignity. And we were the first human rights organization who sent mobile groups to Crimea, to Lugansk and Donetsk regions to document war crimes. And also in 2014, we started campaign to promote ratification of Rome Statute. And one of the results of this campaign was two declarations which Ukrainian parliament sent to International Criminal Court, as well as change in Ukrainian constitution, which opened the way to ratify Rome Statute of International Criminal Court. And unfortunately, Ukraine haven't done this yet. But when large-scale invasions started, we faced with enormous amount of crimes. And that is why we united our efforts with dozens of organizations from different regions into one Tribunal for Putin initiative. We created all Ukrainian network of local documentators, and we have an ambitious goal to document each criminal episode which was committed in the smallest village in each oblast in Ukraine. And working together, we have in our database for current moment more than 45,000 episodes of war crimes. And this is a huge number, but still a tip of iceberg, because Russia uses war crimes as the methods of warfare. And Russia attempts to break people resistance and occupy Ukraine by the immense pain of civilian population. So we document this pain. We witness how quickly war turned people into the numbers, because the scale of war crimes grows so large that it's become impossible to recognize all the stories. And that is why I will tell you the story of my friend, Ukrainian writer Victoria Melina, who joined the documentation work last year, who regularly visit East to gather testimonies of victims of war crimes, and who was recently died after when Russian rocket hit the cafe in Kramatorsk. And Victoria documented Russian war crimes. She was an extremely brave woman, and now she became a victim of one of such crime. So what I want to tell with this example, I want to tell that we all have a huge responsibility, because we know that we can't stop human suffering just now, but without our efforts, nothing will be stopped. So we have to fill the accountability gap which we faced, and this gap has two dimensions. The first dimension is that there is no international court which can prosecute Putin and high political leadership, top military command of Russian state for the crime of aggression. This is a problem that still International Criminal Court has no jurisdiction over the crime of aggression in situation of Russian war against Ukraine. And this is responsibility of countries who are members of Rome Statute, who made this Kampala consensus so modest that provide no possibilities for international court to step in. And that is why we have to change it in future, but for current moment, we have to establish a special tribunal on aggression and hold guilty in this crime accountable, because all these atrocities which we now documented, it's results of leadership decision to plan, to initiate, and to start this war of aggression. But second dimension of accountability gap is even much more serious. We closely work with International Criminal Court and find its efforts very essential. But we all know that based on this policy, International Criminal Court will limit its investigation only to several selected cases. And this means that the main burden of responsibility to investigate and to prosecute war crime perpetrators still lay on national system, and national system have already been stocked. For current moment, only official, the Office of General Prosecutors opened more than 92,000 criminal proceedings. And 92,000 criminal proceedings, it's impossible to investigate for the best Office of General Prosecutor in the world. So we need international assistance to investigate war crimes, crimes against humanity, and genocide, like a way to how to implement national element into the level of national investigation and national justice in order to make national systems stronger and more capable to face with this enormous challenge. I work directly with people for several years, and I know that people affected by this war see justice very differently. For some of them, justice means to see their perpetrators under the bars. For others, justice means to get compensation and reparations. Other people just want to know the truth, what happened with their beloved ones. For other people, justice means that they have, they need to receive official recognition that something which happened with them or their families, it's not just immoral, but illegal. And that is why we have to elaborate the complex justice strategy to reach all these needs of people affected by this war. And also this strategy, this composition, this architecture has to be able to provide a chance for justice for each people, regardless who they are, what types of crime they endured, what their social position, and whether or not international media or international organizations were interested in their cases. Why we have provide justice for all? Because the life of each person matters. This is very simple. And if we say that justice is universal value, we have to make the justice as a universal service. And I do believe that in 21st century, with all digital tools which we now get, which help us to restore what happened, to gather evidence, to identify perpetrators more efficient, more quickly, in a way in which we can't even dream 30 years ago, we can manage this task to fulfill. So I stopped on the point that there are a lot which has to be done by international communities, but also there are several tasks which Ukraine themselves has to do. First, Ukraine has to ratify Rome Statute and to send a strong signal to the world that we join the club of states who jointly struggle against international crimes and impunity. Second, Ukraine has to harmonize our national legislation with international criminal and international humanitarian law, because we still have no responsibility for the crime against humanity. And we are in an absurd situation when we have a lot of crimes against humanity, which reported by International Commission on Inquiry, which was created by UN Human Rights Council, by other officials and mandate structures of Council of Europe or UN, but we have zero criminal proceedings on it. And I will stop here with my experience that I know that people who went through hell, they need to restore not just their broken lives, they need to restore their broken belief that justice is possible. Thank you.
Thank you. Thank you so much, Alexandra, for both laying out the issue of the framework of justice that's needed, but also to remind us that ultimately, yes, victim needs justice and need to experience the world as a just place. And that is part of why we think of the ultimate justice as potentially reparative, that we repair not only ideally the individuals, but the world around them. Mr. Joseph Aqueniu Manoba is a human rights lawyer, co-counsel in the representation of victims in the Ogwen case before the ICC. He has you heard Judge Schmidt refer to the case. He has previously served as legal advisor of the Uganda Victims Foundation and coordinated the Uganda Coalition for the International Criminal Court. He has been active with grassroots organizations promoting peace, justice, and the rule of law in northern Uganda. Joseph, the floor is yours.
Thank you, Yael. Like all the previous speakers, I am very honored to be here, and I thank you for the invitation to speak and share my own experiences in the Dominic Ongwen case. As perhaps many of us may know, the Dominic Ongwen case is a very significant case for victims. Dominic Ongwen is 1 out of 5 indicted LRA commanders, 3 of whom are believed to be deceased as we speak, and only one chairperson or commander of the LRA, Joseph Kony, is still at large. So the Dominic Ongwen case is very significant for the various victims that you will find across northern Uganda. As legal representative for victims, I was honored to speak to my clients from the very start of the case, and I can tell you that none of those victims that I represent could positively recognize Dominic Ongwen as the person responsible for the attacks on the at least the 3 IDP camps that our clients resided. And so his trial is very significant because he's the first person among the 5 commanders that LRA commanders that have been indicted, who has been found guilty for the crimes that were perpetrated against the victims in the 3 IDP camps that I have mentioned. Of course, the trial altogether relates to 4 IDP camps, internally displaced people's camps, and the crimes that were committed in these locations. The judgment obviously was very welcomed by the judges, by the victims of the crimes for which Dominic Ongwen was convicted, because of many factors. One, it enabled the victims to know the person who was responsible for the attacks on these 4 IDP camps. As I mentioned earlier, none of them could positively identify Dominic Ongwen. But with this judgment, with this decision, all of them know the truth about the attacks. They also know the truth about the crimes that were committed and how Dominic Ongwen was responsible for these crimes in these locations that the victims hail from. Interestingly, in their decision, the judges do mention the individuals that were killed in all these 4 locations where the victims are found. And when I and my team were speaking to the victims about this decision rendered by the judges of the trial chamber, and we mentioned this, it evoked emotions in the victim community, because they understood that the judges appreciated the kind of impact of the attacks on them, knowing or hearing that the judges recognize a father, a sister, a grandfather, an aunt and uncle as the person who was killed in the attack, was very important for the victims. You should have seen how the emotions were, being shown by these individuals, and it's not because it simply reminded them about the unfortunate incidents, but the significance of the judges mentioning every individual that at least the evidence showed had been killed in the attacks was very important for the clients that we represent in these proceedings. Of course, we have mentioned victim participation in this process of this discussion. The opportunity to participate in these proceedings, the International Criminal Court proceedings, has been equally very significant. Not everybody, as you can imagine, had the opportunity to present themselves before the judges, because it is impossible. I mean, we represent 4,000, victims in total who are participating in the proceedings are about 4,605, and not all of them could be allowed to participate or present themselves as witnesses. But as we did speak to these individuals, at least me and my team had the opportunity to engage one-on-one with a number of individuals. And for the first time, many of these people were able to speak and express and tell their stories about the incidents that happened to them. I can tell you a number of these individuals having this opportunity to speak to us for the first time lifted heavy burdens off their shoulders. They may not have had that opportunity to appear before the judges, but they have kind of received a healing that would not have happened if they did not participate in these proceedings. Obviously, we cannot fail to mention, and you heard the judge mention the fact that they received views and concerns of the victims. We constantly engaged the participating victims, sought their views, sought their instructions, and we communicated these instructions and their views to the judges. Unfortunately, we are glad that the judges did recognize most of these views and concerns and took them into consideration in their decision. Of course, our presence as legal representatives for victims in the courtroom alone was very equally important. We have received constantly, approval, signs of approval, or perhaps appreciation, I should say, from the participating victims, that seeing us in the courtroom speaking about the things that we had consulted them about was very satisfying for our clients. Of course, the routine engagements where we get information about the proceedings in the courtroom and communicating them to the victims has equally been very well appreciated by the victims. And obviously, the victims have had the opportunity to be conscious about what is happening both in the courtroom and within their environments. Obviously, as you can imagine, even with the trial ongoing, there will be misleading information in the public. And so hearing this information from us as the legal representatives for victims helps to give them consciousness, awareness about what is happening in the courtroom. Now, the other thing that perhaps I want to mention is the outreach. Obviously, the court has a public information and outreach section that is responsible for providing information to the victims. Unfortunately, in my experience, I'm not sure if the public information and outreach section of the court does share information the way the legal representatives for victims share this information with the public, because some of the things, as you can imagine, are technical in nature, and perhaps the public and information outreach individuals may not have the skills or the appreciation of the law as we do. And so when this information is shared with the general public, it may cause confusion on the one hand, and so we do not have control over that. Now, for those, because our mandate is limited to only the participating victims, we can only help those participating victims appreciate what is happening or the decisions that the court has rendered. And so in many respects, outreach may have its own challenges. I can mention to you that in the course of this trial, we did speak to individuals men who were sexually abused by the LRA. We tried, obviously, to make an application before the chamber so that some of these victims could be, given an opportunity to speak. as witnesses on the basis of those charges that had been confirmed against Dominic Ongwen. However, we were not successful because the judges argued that this was an issue that was never presented during the confirmation charges. But perhaps if the prosecution had done the prosecution and maybe the outreach office had done proper outreaches to the communities, then this is an issue, an area that perhaps the office of the prosecutor could have considered and done some investigation so that these victims, male victims of sexual and gender-based crimes, are properly represented in of course, the proceedings. Perhaps one thing that I can say more is right now we have in the domestic proceedings a trial against one of the LRA fighters, and so the trial of Dominic Ongwen going forward gives it offers precedent for the national proceedings against LRA fighters and LRA commanders that may be tried before these national courts. Although victims' participation hasn't been given that significance in the proceedings, but I think nonetheless the whole proceedings against Dominic Ongwen offers national courts in Uganda or perhaps in the region an opportunity to kind of consider some of these aspects relating to victim participation in the proceedings. Thank you very much.
Thank you, Joseph. And after the comments from Judge Smith, also in your case, you really played the role of common legal representative in performing the letter and the spirit of Article 68.3. You really conveyed to your compatriots, the victims whom you represented, the court proceedings. And yes, your work could have been maybe even better assisted by more proactive and clear and anticipated, I would say, outreach, because we in the victims' rights working group since the early days were making the case that as soon as there is an investigation, there is a duty of notification to all the affected communities so that they can come forward and they can enter into a two-way communication from the very, very start, even before the pre-trial investigations start, at the phase of examinations and then initial investigations. But I know this is something that the court would need to reassess also with augmented resources. Let's remember that today, the budget of the ICC in the United States dollar value is less of what the Security Council and the United Nations were giving to the ad hoc tribunals in the year 1999 or 2000, looking at inflation. So, but this is a court that doesn't look only at former Yugoslavia or only Rwanda. It's a court that looks at so many situations and cases in all regions of the world. So there is really a mismatch there, and much more needs to be done in that area. Now we move to two commentaries. And the first one is really a dear friend of mine, whom I had the chance to meet more now that I ended my job as head of a major international NGO than ever in the past. Ugo Relva is the legal advisor for Amnesty International Justice Team based in Argentina. He has been really a leading figure for all of us in following some of the major newest development. I'm referring to the Mutual Legal Assistance Treaty adopted in Ljubljana a month ago that creates a network of cooperation among states in the fight against impunity and also for victims' rights, as well as the hopefully upcoming, not yet upcoming though, Crimes Against Humanity Convention, which is now in the status of draft articles sent by the ILC to the UN General Assembly 6th Committee. Ugo has really a huge experience in international criminal law and international human rights law, and it's a great pleasure to having you. Ugo.
Grazie, David. Yeah, I would like to focus my brief intervention on perhaps a different aspect, on the question of the title of this meeting, the impact of the Rome Statute on victims' rights. and looking at this question for the next 25 years, I think that the impact of the Rome Statute has been terrific. And victims are today, David, in a much stronger position than 25 years ago. We should, in my view, bear in mind that the International Criminal Court is going to try only a handful, a limited number of persons suspected of criminal responsibility for crimes under international law. So the main responsibility lies on the state's side. And I would like to mention briefly 7 examples of where the Rome Statute, in my view, has had an impact on our daily life in our fight against impunity. The first one is the question of universal jurisdiction. Soon after the adoption of the Rome Statute, Judge Garzón in Madrid issued an arrest warrant for the arrest of Augusto Pinochet. It was the first, after the Eichmann case in the 60s, the first case of universal jurisdiction. It was an exceptional case at that time. Then the Hissène-Habré case came years later, and today there are, I think that perhaps more than 20 states exercising universal jurisdiction or other extraterritorial jurisdictional bases, including South Africa and my country, Argentina, who both exercise universal jurisdiction. Not only European states are putting into practice this core principle of international law, which is universal jurisdiction. A second example where I think the Rome Statute has had an impact on victims' rights today is this question of implementing legislation. The vast majority of states parties to the Rome Statute, I think around 70, have already enacted legislation implementing the Rome Statute into national law. And by doing so, they have made crimes under international law criminal under national law. The vast majority of them are provided for universal jurisdiction as a potential tool against impunity, the non-applicability of statutory limitations. Many of them are provided for the non-applicability of amnesties and other similar measures like pardons, for example, or responsibility of commanders and other superiors, and a prohibition on superior orders. So the advancement of international criminal law in national law has been incredible over the last 25 years, and it's expected if we succeed in the future to convince more states to become party of the Rome Statute, and then if they implement the statute into national law, the coverage of the national legislation will be perhaps truly global. Another example, which I think it's important to mention, is the adoption in 2006 of the International Convention for the Protection of All Persons from Enforced Disappearance. So far, until 2006, in terms of random or isolated crimes, we only had torture from 1984, the convention. And now this convention in 2006 had the two peculiar, questions, which is, first of all, it is the first conventional instrument in recognizing the right to truth, the right of victims to truth, and a definition of victim, a very good definition of victim. Another example, which I think it is a consequence of the adoption of the Rome Statute, is a number of ad hoc tribunals, hybrid courts, set up in different countries, like in Sierra Leone, Kosovo, Timor-Leste, Cambodia, aside the ICTY and ICTR before the adoption of the Rome Statute. And hand by hand, sometimes, has not been possible to establish an international criminal court, but there are some Geneva-based investigation mechanisms like the IIIM for Syria or the IIMM for Myanmar. And as you mentioned it before, I think two important, one crucial, advancement has been a month and a half ago, was the adoption in Ljubljana, Slovenia, of the Convention on International Cooperation on Genocide, Crimes Against Humanity, War Crimes, and Other Crimes, a convention which contains a super positive text, which is plenty of positive provisions, aside some minor flaw provisions, but basically it's a very good treaty, which exponentially expand the scope of jurisdiction of states to be vested on national courts, which, for example, I don't know if all of you are aware, but remember Article 7.3 in the Rome Statute, this, odd definition of gender has been abrogated in the text of the Convention on Cooperation for Crimes under International Law. It also contains a definition of victims based on the Rule 85 of the Rules of Procedure and Evidence of the International Criminal Court. It contains plenty, a chapter on victims' rights, including asset recovery for the purposes of reparation. And finally, you also mentioned it, it is, I think, likely today that the new Convention on Prevention and Punishment of Crimes Against Humanity could be adopted in the near future. And when I say near future, it's not next year, but perhaps in a couple of, this whole question of the draft convention, which is an output by the International Law Commission, a subsidiary body of the General Assembly, was put for the consideration of states in 2019, and then was blocked at the 6th committee, just because, unfortunately, decisions at the 6th committee are normally taken by consensus. But due to this war in Europe, which has exacerbated, everything in our world, many states were decided to force a vote in the 6th committee, and then suddenly a new consensus show up that permitted to resume sessions this year and next year to discuss in depth all articles of the draft convention on crimes against humanity, which, by the way, aside the fact that we and Amnesty, David, are suggesting some improvements, basically it's a very good draft treaty. So to sum it up in few words, I think we are today in a much better position, despite, some failures. I'm fully cognizant of that, but I think we are in a better position than 25 years ago, and that's positive. Thanks.
Yael? Yael, we cannot hear you. You should unmute.
I'm very sorry, thank you. I said, what a happy note. We have a lot to talk about still, because we submitted some comments on the victims' provisions of the convention. We should share them with you too. So, but that's more to the dialogue time. I would our last commenter, and then we will open the time for dialogue, and only then we open time for question and answers from the audience. It deserves a great deal of admiration. Dr. Saimia Uma, I admire you. You're in the middle of the night. You've been sitting there looking beautiful while everyone around you is asleep. Thank you for your dedication. So Dr. Uma is a professor of law at Jindal Global Law School, OP Jindal Global University, India. She authored several articles in the book on victims' rights and international criminal justice. As a human rights activist, she served as coordinator of ICC India, a campaign of the CICC. That's the coalition for the ICC we referred to earlier, in the year in the years 2000 to 2010. Sonia, please. Thank you so much. Go ahead, dear.
Thank you for the kind introduction, Yale. Thank you to ICMGLT, and thank you, David, for the invitation to join this panel with so many experts from various parts of the world. So it's really an honor for me, and I'm very excited to be here, although it's 10 p.m. In India right now. To me, in my small intervention, I'm going to be talking about victims' rights and the ICC in terms of its relevance to India and the rest of South Asia. To start with, the Rome Statute of the ICC is much larger than the court. We all know that. And it creates new, now not so new, but progressive normative standards through a process in which there was a worldwide participation of civil society, of social movements. Such normative standards have special relevance to all parts of the world, of course, but particularly in those countries which are not members of the member states of the ICC. So India is not a member state of the ICC, yet in many ways, the ICC standards brought through the Rome Statute are relevant to our work, relevant to the work in South Asia as a whole. And this is because there is no compulsion in the in those countries which are not member states. There is no legal requirement to bring the domestic laws in conformity with the international standards created by the Rome Statute. So in those countries, advocacy through victims' rights groups, through other civil society groups and social movements, awareness raising, advocacy, these are what help strengthen the domestic legal systems so that the impunity gap is reduced. So ICC India, which was the Indian campaign on the International Criminal Court, it was an anti-impunity campaign against mass crimes in India. The main objective of the campaign was to popularize and make civil society see the relevance of the Rome Statute and the standards that it brought for law reform in India, so that victims could be better protected and their pursuit for justice could be made easier. In South Asia, as many of you know, there are only a handful of countries, in fact, 3 countries, which are state parties of the ICC. That's Afghanistan, Bangladesh, Maldives. Yet mass crimes, particularly crimes against humanity, are being perpetrated in many of the South Asian countries. So how does the ICC really hold any relevance for victims in this region? I will highlight some ways, and of course, with a radar that these are all ongoing efforts and initiatives. So one of the things that that victims' rights groups as well as civil society groups in India and other parts of South Asia engaging with international law standards, particularly ICC standards, concepts of genocide, crimes against humanity, command and superior responsibility, victim and witness protection, standards related to victim participation, reparations for victims, particularly for sexual and gender-based violence. So these are very, very important concepts, standards, but many of these do not exist in the national legal systems in the South Asian countries. So what the Rome Statute means for us is that it provides a language for some of the crimes that are committed. It provides a procedure. It provides rights. So there are substantive rights as well as procedural rights. It even throws light on what are the kinds of, how is evidence to be ascertained in such situations. So ICC India campaign, for example, popularized many of these concepts, and these then came to be incorporated in the domestic law reform initiatives. For example, there was a bill called the Communal Violence Bill, which was primarily law to address impunity in situations of targeted attacks against people, against civilians, particularly in terms of religious identity. So while the human rights movement, civil liberties movements in India and the women's movements worked on this communal violence bill, many of these Rome Statute provisions and concepts were aspects that were incorporated into this bill. Of course, the bill has still not been enacted into a law, but this is an ongoing, ongoing initiative. Second is in pursuit of justice, particularly when pursuing justice for violations that women, children, religious minorities face. We draw upon international standards, including the Rome Statute's provisions, in addition to the provisions from the national constitution. And this is to advance the discourse for justice. For instance, there were 11 persons who were convicted in an incident of gang rape of a religious minority woman. And her family members were raped and murdered too. And she was the sole survivor. And she complained, and then there was a trial which went on for a long time. And then 11 people were convicted in this particular trial. And before they completed their sentence, on the basis of remission, based on their good behavior in jail, they were released. So it was a premature release from jail before they completed the sentence. So the victims' rights discourse was used in this instance to argue how such a premature release or remission of the convicts without giving due consideration to the victim's concerns about her safety, her family's safety, this actually violated international norms, including the ICC statute. Third example, trauma faced by victims and ascertaining the evidence of victim, taking trauma into consideration. This is an area of advocacy as well, especially where trauma is faced by women and children who face sexual and gender-based violence. What the civil society in many of the South Asian countries is doing is to try and sensitize the judges, sensitize the law enforcement officials, the investigators, the court officials about the trauma faced by the victims and how they should be treated in court and how the evidence that they give should be ascertained in order for a, during trial. So that is a third area where there are efforts that are going on. Fourth area is protection to victims as witnesses. Some decades ago in South Asia, witness protection was synonymous with witness relocation and giving a fresh identity with facial reconstruction surgeries and so on. Now there is an attempt to understand and to protect witnesses who depose before courts of law, particularly in heinous crimes. And this largely has drawn inspiration from the Rome Statute. One-way mirrors, closed-circuit cameras, these are all being used, safe passage to and from the court to the residence of the witness. This is being provided. In Delhi, for example, there is also a vulnerable witness protection complex. This is available at the district courts in Delhi, and there is an effort that is being made to extend this to other states as well. So these work on not only protecting the witnesses, but they are trying to understand and address the particular vulnerability of witnesses who are also victims and the need for special protective measures for them. So the Rome Statute and the standards that it sets are very useful in this as well. The need for special in-court protective measures, support systems such as translations, interpretations, counseling, child support, and the need for personnel with expertise in gender issues. So these are all aspects where advocacy is going on, and we take a lead from the Rome Statute for this kind of advocacy. Fifth aspect is victims' participation. In trials, often victims are prosecution witnesses and nothing more. Even though we know that victims are the most affected in the entire trial, very often in domestic legal systems, particularly in South Asia, victims are prosecution witnesses. When the prosecutor calls them to court, they go to court. Very often they are seeing the court for the first time. The prosecutor's too busy to even acquaint them with the procedures and so on. They have no idea what is happening in the trial. But victims' participation as a concept is again something where ICC and the Rome Statute, as well as the practices in the ICC, have actually shown us light as to how victims can participate. What are the stages where this is possible? How do we balance between victims' participation and the rights of a fair trial, rights of the accused? How is it that we can ensure that the victims know when a bail is being issued or what is being argued in court, and taking part in the crucial aspects of the trial, including on punishments and so on. So domestic law reform measures are taking place slowly in domestic criminal law on the aspect of victims' participation. Sixth aspect, reparations. Compensation is an established legal right in many of the South Asian countries, but domestic laws have not really acknowledged or incorporated reparative justice of victims beyond compensation. So aspects such as restitution, rehabilitation, apology, guarantee of non-repetition of the crime, satisfaction, these are all aspects which still haven't found their way into the South Asian criminal law systems. And when victims' rights are argued before courts of law and in policy making, these aspects of reparations are useful to provide a fuller protection of victims' rights. And again, it is from the Rome Statute that we draw inspiration for this. Very quickly, I want to highlight some issues of discussion on victims' rights in India and South Asia. And I'm just, one of the aspects of discourse, for example, is should we be using the term victim or survivor? If we use the term victim, are we portraying victims to be passive subjects rather than active agents of justice? So this is a question which is often posed when we talk about victims' rights in India and in other parts of South Asia. And one of the responses that we give is about how victim has a very specific definition in international law. including the Victims' Declaration, Van Woven Principles, and of course the ICC statute. And that many victims, unfortunately, do not survive the violence to be, they do not survive. And even if they survive, it is a journey to move from victim to survivor. And when we talk about victims' rights, it also puts a responsibility on the state to protect those rights. And this is why it's important to use the term victim rather than a survivor. So this is one of the discourses that we have within the country. Another question that often keeps getting asked is, what happens if the victims demand death penalty, or they demand other harsh and cruel punishments to be given to the perpetrator? Should we actually comply with the victim's demands? To what extent can we acknowledge victims' rights in those cases? Some of you would remember a very, very heinous gang rape and homicide that happened in Delhi on a moving bus. This happened in 2012, December. And the outrage that came after this rape, the public outrage was such that many victims groups had demanded castration of the rapists. So these are cruel punishments. So if the victim demands such a punishment or death penalty, does that mean that the victim's demands should be complied with? And the answer is that the victims may have a say with regard to punishments, but the determining authority is really the judge, and there are applicable laws and there are international human rights standards as well. So death penalty or other torturous punishments are really not an answer. A third question that keeps getting asked is, what happens if a huge number of victims wish to flood the courts in pursuit of justice? What should poor countries like India and other South Asian countries, how should the courts be handling this? And the answer is, of course, that they can be represented by a few lawyers or few law practitioners. And this is a phenomenon that is particularly, it's not unfamiliar to India, because there was a Bhopal gas tragedy where there was a gas leak that resulted in thousands of victims dying and also getting injured, and lots of extensive human damage. And they were represented by specific lawyers, and there were victims groups as well who advocated for their own voices. As Carla reminded us, victims' participation is not merely about protecting their legal interests. It's also about amplifying, it's about empowering victims' voices. And such empowerment can happen sometimes through victims' rights groups that issue statements, they hold press conferences, they organize themselves, they articulate what they want, what are their needs, what are their interests. In South Asia, there are many such victims groups and networks working, for example, on torture, on enforced disappearances, on religion-based violence, and other heinous crimes. So these are some of the questions that keep getting asked, and I thought it might be interesting to international viewers, this kind of discourse on victims' rights that goes on. So to conclude, in India and the rest of South Asia, the Rome Statute and the normative standards that it brings, they are of extreme relevance to strengthen the domestic legal machinery and to bring home the ICC standards on victims' rights. So my vision for the next 25 years on ICC and victims' rights is really to bring home the Rome Statute standards, That will ensure that states are able to prosecute offenders for ICC crimes. When there is an unwillingness on the part of the state, of course, there will be civil society groups, and then we have the ICC as a safety net. But bringing home those ICC standards is important for women, for victims' rights, particularly vulnerable victims' rights, like women, children, religious minorities, and so on. It is important for victims' rights to justice to become a reality. Thank you.
Thank you very much, Soumya. And I think really your perspective from the largest state non-party, because India has more people and population than China and the United States, it's helping us to also understand that, there is a lot of work to be done. And we have leaders already there on the ground, like you. So I think it's also very positive what you have been saying, and the next Indian government should ratify the Rome Statute. Yael.
Yes. As you can see, we almost consumed the whole time, which is always what happens. There is so much to share. Actually, I think each one of your commentaries deserves a whole day seminar. So we'll have to continue this dialogue. And let's just take, but truly, only 5 minutes for a dialogue among you. Is there anything you would like to comment about each other's interventions? Because we have quite a few questions and comments from the audience, which we promise to take on. So, Carla, please, you've been, you know your own presentation, and you've listened to so many others speaking about the internal aspects of the court and the external aspects of the court, right? As an inspiration for the world. Please.
I just wanted to comment on Soumya's presentation and the fact that the Rome Statute serves as an inspiration for domestic jurisdictions, and also to bring in Joseph in relation to Ugandan domestic criminal law procedure. My recollection of the Special Crimes Division is that also a common law country, which isn't used to having victim participation. The ICC procedure, the statute, was very much helpful to Uganda in developing at least a modicum of victim participation. And I think that was really quite important. So it's just a comment that I wanted to make.
Unmute everybody. We are talking with each other. Go ahead, Joseph, and then Soumya.
Yeah, absolutely. I mean, Carla is right. Obviously, I and Carla did work together previously on lots of things around victims' participation. Unfortunately, because of this common law system that we have in Uganda, like India, I guess, there is a reluctance by the judges that sit on at the International Crimes Division to, allow, a better or more active participation by victims. I have been approached by colleagues that are representing victims in that case at the domestic level. And I have advised, of course, and shared some of the pleadings that we have used in the Onwen case to kind of convince the judges that, their participation of victims doesn't necessarily, if there's a good balance between the prosecution and the rights of victims, then it shouldn't be hard for the judges to, allow victim participation. But it hasn't really, It's been very helpful, I guess. But as I said, it is a work in progress. I am quite confident that if we have more victim-sensitive judges on the bench, we might have that changing along the way. Obviously, the jurisprudence of the ICC cannot be ignored. I think it is very important. One way or the other, the International Crimes Division will learn to apply some of this jurisprudence to its processes at the domestic level. Thank you.
Any other comment, question to each other within the panel? I guess not. So, but what you don't know yet, I have a sneaking mission here to also add you all to the to our working group on justice of the International Center for Multi-Generational Legacies of Trauma. So this is a formal invitation, please. And I'm sure David will agree with me. If not, David, would you take on the questions, the comments from the audience, please?
Yes, thank you very much, Yael. And I think there is a very...
Let me just do one more thing about the center. I'm so sorry. Just to Alexandra, it's important that you know that we have a special working group on Ukraine. And in fact, one of the questions that David will present to you is from the chair of that working group. So go ahead, David, sorry.
So this is from Dr. Irina Frankova. And she's asking to Alexandra whether support and protection systems for victims, including psychosocial support, exists in Ukraine. And if not, whether there is a room for its establishment. Alexandra.
Thank you very much. It's a very important question which needs detailed answer, but I will try to be brief. The problem is that we have now enormous amount of people who need psychological assistance. When you spent last night in corridor and can't understand either thunderstorm or next Russian challenge, even if you're far from of the battlefield, you can get trauma very easy, especially when all of us, according to sociological survey, I mean, more than 80% of Ukrainians told that in their closest circle, in family or among their friends, are people who were killed in this war. And so, like, a lot of people need psychological assistance, and it can't be covered by private volunteers, civil society initiatives, and there are a lot of has to be done to establish a proper state services. But what also it's push us to think how to create additional direction to provide healing of the pain to such a huge amount of people when you can't provide individual psychological treatment. I am ambassador of All Ukrainian program on psychological health, and this program advertise a very simple methods and techniques how to be more responsible to yourself and to people who are around you, how to recognize some dangerous thing, and how to provide at least something support and prevention. It's and to be aware of your current state and to be able to recognize what can help you and feel your energy. It's also one of the tools. And also, I think that we need to work together with people from culture, from different social studies. Education as well. And to think what we can ingrain in public culture, like some rituals, some traditions, which can transfer this pain into the energy which enabling life. So this is my very brief answer to this very important question. Thank you.
This links us to comment that many of the speakers made, starting with Carla, which is about the state responsibility to provide reparations, which is not detracted from the Rome Statute construction. In fact, in the Rome Statute, we have what we call the non-prejudice clause. Whatever the court system can give directly to the victims, even through the trust fund for victims, is not prejudicial to what more can be given and provided by the state on whose territories the victims are located. And we have seen it with the Holocaust survivors. Their reparation programs are still ongoing now, 75 years after their victimization. So I think what we need to also come up for the next 25 years, if I can bring something to the table on my side, is like to place state responsibility much more central to the realization of victims' rights, not only for example, for the purposes of guarantees of non-repetition. The only ultimate guarantor is the state, because if Russia doesn't stop invading Ukraine, crime of aggression doesn't stop, and the millions of Ukrainians who are victims of the crime of aggression will not cease to be victims. So cessation of the crime is one of the conditions for the guarantees of non-repetition, which needs to be given also by the former perpetrator once there is cessation. So it's really a broad dimension that we are bringing in here. And I invite you, Alexandra mentioned the crime of aggression. I invite you to look into the webinar that we did with in ICMGLT together with PJ on the 21st of September, which identifies the crime of aggression as one of the crimes that brings about the largest and most severe type of victimization, a crime of mass atrocity like the other ones that should not be detracted. So what Alexandra said about amending the amendments it was a major focus, is something that hopefully
right. And what was important was that I actually spoke then about victims of aggression in particular, so it could feed into in the initiatives. But I want to remind you, and of course, Alexandra, I don't need to remind you, but just the same, we know from history that when victims are not healed, the children carry the wounds, not even the scars, the wounds. And it goes from generation to generation. So the obligation the international community and society and local community have for future generations is to heal the victims, and not just provisionary, easy measures. I'm not putting them down. Right now is different from what will be after. Okay, right now we do need a soothing measures. But I think part of when I speak to other people to raise funds, for example, I speak about investing not only in rebuilding infrastructure, but rebuilding people. And so at least as equally important. So, and to teach the international community about that. And to just mention to everyone, in October, we will have another webinar exactly on special issues. Again, focusing on victims, but special issues such as victim survivor, such as multi-generational legacies of trauma, etc. So this conversation is not ending right now. It's just beginning. So I thought it's important that we say that. David, there were many, many excellent comments in the chat. Do you want to attend to them? Maybe to even invite Adam, Carol, are you still here? I don't know, he was addressing you, Dr. Umar, about Bangladesh and the victims from Myanmar. There, maybe you can say a word about that, but again, 1 or 2 sentences, okay? Because it's such a huge tragedy. We're talking about such huge tragedies. Would you please?
Thank you. I think I have given my comments in the chat box, but basically, yes, it's an important issue to raise, you know, about the Rohingya victims and what has happened recently and the lack of protection for those victims in the relief camps, and the state responsibility to ensure safety and security for these survivors is definitely there. And, you know, the leadership, the political leadership, we do look forward to their cooperation with the ICC. And this kind of a political willingness to cooperate is sometimes going to happen through civil society initiatives, that kind of, you know, dialogue with the governments and so on. So there are vibrant civil society initiatives, victims' rights groups, both in Bangladesh as well as in other parts of the region. And those are seeking to advance and talk about these rights. So we are hopeful that this will, you know, we will see some positive initiatives that will be taken. Thank you.
Thank you.
Thank you. Yes, I think Adam Carroll was making a question about the creation of political will in states that have not joined, with particular reference to the United States government. So I don't know if Ugo, as a leading member of Amnesty International, would like to say a few words. Certainly Amnesty International in the US is promoting the fight against impunities as it does elsewhere. And of course, Yael is a member of the Washington Working Group. So you can say a few words. You can say a few words about it.
There is a Washington Working Group of the ICC, and those of you in those United States who live here and want to join, I'm sure there's just write to me and I'll put you in touch with the organizers. But you go, please add your point of view. That's really important.
Oh, thanks, Yael and David. I'm deeply, deeply sorry. I have to leave. I'm arriving late to another meeting to discuss Venezuela and the ICC. My colleagues are sending me messages of all sorts, so I'm deeply sorry. Okay, I hope to be able to continue very soon. Super sorry.
No problem, no problem.
But you consider yourself a member of the working group.
Yeah, sure. Thank you. Thank you. Bye.
Thank you so much for your contribution.
Thank you.
There are consistent efforts by many NGOs to promote universality, implementation, the fight against impunity through universal jurisdiction. So, you know, it's really, and even surveys have indicated repeatedly that the majority of the United States population supports the ICC. Once there was a very thorough exercise, and it came to the realization that almost 70% of the United States people interviewed were in support of supporting the ICC. So, and there are voices in the United States Congress like Jim McGovern, the co-chair of the Tom Lantos Human Rights Commission, who supports ratification since 2014, not since yesterday. So not connected only to the Ukrainian crisis, but the invasion of Ukraine brought about a huge development into US law. Now the US has universal jurisdiction on war crimes, and there are renewed initiatives to have crimes against humanity.
Because of Ukraine also, of course.
Yes. So the situation has changed. Maybe in other countries, like in India, we have a retrogressive position advancing more than a progressive one. So the world is deeply divided around the ICC, but I think the majority of states are in support of the ICC. And we need to continue, because those who are in power, like Mr. Putin is now under an arrest warrant, they will not live forever. History tells us that things can change anywhere and everywhere. So we need to continue the struggle, never give up, as Ben Ferencz taught us. And surely sooner than later, things can change. So political will is really something that shall be built in our everyday work, and not considered, never, even when it exists, it's never for granted.
Yet. And don't forget cultural will, please. I think when we always talk about political will, we forget that some cultures make it more difficult to have political will. So, so we need sometimes to look at that. And I'd like to make one connection, if I might, between Carla's absolute right insistence on involving victims, that involving victims on every decision about themselves is empowering and healing and reparative, and Joseph's mention of outreach. And I think that's an important lesson also to victims in Asia and in Ukraine. Why am I saying outreach? In my experience, the victims who are hardest hit, who are most beaten, would not come forth, even if there is the customary formal outreach. We have to reach out to them and take them by the hand and give them enough strength to come forward, not just to announce to them that a case is happening. So I don't want them to be forgotten. Okay, and for me, this is always the painful issue that's left. Don't forget anyone. Don't leave anyone behind. In as much as it sounds like just a saying, because those who are beaten are the ones who would not bother you. Would not have the power to speak up, the emotional power to speak up. They need you to hold them forward. And part of the cultural will I'm speaking about, not just the political will, is to teach the world that victims have rights. It will also probably deter potential perpetrators. So I don't know whose auspices I'm speaking to, but before I die, I want every victim or potential victim around the world to know that they have rights. And I want every person who consider even daring to be a perpetrator to know that victims have rights. And that is part of what we mean by justice. So.
Can I say something
Please.
Additionally? Yeah, earlier when Judge Smith concluded his remarks, you asked the question how, as judges, they deal with hearing these stories. And I thought that's a very interesting question that you posed to the judge, because in my experience representing victims, I hear more kind of atrocious stories than the judges get to listen to. But within the ICC mechanism, you do not have support for legal representatives for victims. So when Carla said that there are lots of things that need to be done with the ICC to ensure that, moving forward, you know, we have a better ICC system in work. I thought this is an area that needs to be discussed, perhaps at another forum. But it's very important that the ICC, the principles within the ICC mechanism and the system that supports the principles needs to understand that you know, these are serious concerns, because if you have counsel who is listening to all these atrocious stories that individuals have, they get affected in one way or the other, and there's no you know, coping mechanism. In our case, we have been on our own, and a colleague of mine did kind of suffer some kind of health issue, and we have no support, absolutely. So it's an area that I think that needs to be discussed in the future.
Absolutely, the healing for the healers.
Yeah, let me say one thing, and then I think we should close because we are 15 minutes beyond schedule.
Yes.
Just to say that in my humble view, yes, many improvements needs to be undertaken on legal aid for victims, representatives, and so on. And also in this respect, the role that you, Joseph, and many of your colleagues have been able to play as a spokespersons for the victims has not been duly acknowledged in the practice of the communications of the court. In other words, the court should have used you to help press conferences and talk to the media alongside with the prosecutor and the defense, so to give a better appreciation what the court does. So much needs to be done from a strategic communication point of view, which is tailored to what also Yael was saying, prevention. Because if the message is out a bit more clearly and aggressively, probably we have a better strength. Ultimately, in my humble view, the biggest fault of the system is the excessive discretion. So sometimes there are choices that are not explained. For example, you know, Afghanistan ratified in 2003, and we have not yet had a case on Afghanistan, and you know, the proceedings took so long. So there are so many questions regarding which the prosecutor office in particular and the court as a whole can respond. But I think for the next 25 years, we have put so much on the table. So thank you.
Carla, what would be, first Joseph and then Carla, last words for today?
Well, I can only re-emphasize the point that, you know, moving forward, you know, counsel that represent victims need support. You cannot just allow counsel to go out there in the communities and not provide them support and their clients in terms of psychosocial help.
I would say my final word is
yes,
that this is really difficult, time-consuming, complex work, and that should not be an excuse for not succeeding and for not trying. We just need to do better wherever we're situated, whether we're situated in the court, whether we're lawyers engaging with the court, or whether we're civil society. We just need to do better and make it work.
these are the best last words. Thank you, everybody. Thank you for the participants who stayed with us until now. And our next webinar is on the 24th of July. It is on Sarajevo, on the multi-generational legacies of Sarajevo, of the siege in Sarajevo and the historic proceeding. But we shall continue with this series as well. Thank you, David. Thank you for being such an incredible right hand.
You're welcome. And thanks to the many.
Thank you, Joseph. Thank you, Paula. Thank you, everybody.